Let's look at the probate process in terms of real estate. Remember the definition of probate given in our introductory presentation. Probate is the legal process of proving who is entitled to control and take possession of property after the owner's death. Real estate is subject to probate in at least 3 situations. First, consider the situation where an owner's name is listed on the deed as the sole owner. The owner then dies. In this situation, the third parties, known as the county recorder and the title company, have a legal question as to who is entitled to take control or ownership possession of the property, or who is legally entitled to sell it. The owner's name is listed on the deed, but the owner is dead and cannot say who should take possession of the property. It is critical to understand in this situation that the owner's last will does not help. The county recorder and title company are not certain whether the will is valid or a fake. All they know is that the owner who is named on the deed is dead. The only valid legal ownership document then in existence is the deed, and it names a person who is now gone as the owner. So who is entitled to take control and ownership possession, or who is authorized to sell the owner's real estate? That question can only be answered in the legal judicial process known as probate. Second, consider the situation where an owner dies whose name is listed on the deed as the last surviving joint tenant. For example, a woman and her husband are named on the deed as joint tenants. Suppose the husband died years before and the woman is now the surviving joint tenant. Upon her death, in this situation, probate is also necessary for the same reasons explained in the first situation. That is, when the last surviving joint tenant owner dies and no one else who is living is named on the deed as another joint tenant or as a beneficiary of the property, then in that situation there is a question in the minds of the third-party county recorder or title company as to who is entitled to control or take possession of the real estate, or who is authorized to sell the real estate. And therefore the legal judicial process of probate is necessary. Again, it is critical that you understand the following point. The surviving owner's last will does not help. The county recorder and the title company are not in a legal position to determine whether the will is valid or a fake. All they know is that the owner who is named on the deed is dead. Consider the situation where the owner is listed as a tenant-in-common owner of real estate and then dies. That is, the owner is named as the owner of a separate, distinct interest in real estate independent of other named owners, an interest we call a tenant-in-common interest. The owner of that interest then dies. In this situation, there is a question still in the mind of third parties, the county recorder or title company, as to who is entitled to take control or ownership possession of the owner's separate tenant-in-common interest in the property. And probate is thus necessary. One last point. As noted in the introductory video on probate, there are several ways to proactively avoid probate. For instance, in regard to real estate, while you are alive, you could just give away your real estate to beneficiaries. Or you can change your ownership document, your deed, and name as joint tenants or tenants in common, people who are likely to survive you. Or you can name a beneficiary on the deed who will take the property after you die. You can also create a trust and name the trust on the deed as the owner of the real estate. There are significant tax, control, abuse, fraud, and cost advantages and disadvantages to each of these methods. For example, there are significant tax disadvantages to naming an adult child as a joint tenant on the deed to your real estate. At your death, that adult child will avoid probate, but may be subject also to significant capital gains taxes. The option of naming a beneficiary on your deed is possible, but this option is subject to serious abuse and fraud. In my opinion, the law allowing this option is one of the most dangerous probate laws in Utah. While a well-drafted trust is the most expensive option initially, it is unquestionably the safest option and the most cost-effective option in the long run in preventing probate, taxes, abuse, fraud, and other problems. You simply create the trust and then change your deed, naming the trust on the deed as the owner of your real estate. In changing the deed, naming your trust as the owner, you have funded your trust. While there are situations where a well-drafted and funded trust is unnecessary, in most situations, it is the best option. This concludes our brief presentation on probate and real estate.